The Connecticut eviction notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in Connecticut. The non-payment notice. According to Connecticut law, there is a grace period of 4 days for 1-week tenants and 9 days for all other tenants. If the tenant fails to pay rent within this period, Connecticut law enables the landlord to send them an unconditional 3-day notice before termination of the lease. Non-compliance notice. If there is material non-compliance with the rental agreement, the landlord should send the tenant a 15-day notice to either correct the issue or vacate. In case the tenant is committing an illegal act, Connecticut laws enable the landlord to send them a 15-day unconditional notice before terminating the contract. In some instances, for example, when the tenant refuses to pay increased rent, the landlord can send a 3-day notice to quit. What if the tenant fails to comply? If the tenant fails to pay rent due and associated fees or remedy the violation, the landlord can file an eviction lawsuit with a Connecticut court. The filing fee is $175 statewide. Then the summons and complaint should be served on the tenant by the court at least 12 days prior to the eviction hearing. After that, the tenant might file a document of receiving the complaint called an appearance and an answer within 2 days after the date listed on the summons. The failure of the tenant to appear for the hearing might lead to the judge's ruling in the landlord's favor by default. If the landlord wins the case, the court will issue a writ of possession. The order will enable the landlord to return possession of the rented premises within 24 hours after the writ is posted or delivered to the tenant. However, the tenant can be granted a stay of execution not exceeding 6 months by the court.